Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott webinar, the NAS report on EEOC's paid data collection, what employers need to know. I would like to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Our presenters are FortneyScott attorneys David Fortney, Bert Fishman, and Nita Beecher. I will now turn the program over to David.
Valerie, thanks so much, and welcome to everyone. We really are glad to be with you today and to have a chance to discuss these very significant developments involving the collection of pay data information and all of the twists and turns that have led us to where we are, and to look down the road a little bit as to where we're going to be. Let me just briefly say a word about who we are for those that don't know. We are FortneyScott. We're a law firm based in Washington, D.C. We focus our practices in counseling and advising and representing clients relating to the workplace agencies in the federal government and sometimes state agencies also in that same space. We do an awful lot of work for clients relating to compensation issues, self-audits, wage gap studies, responding to government audits and investigations relating to these matters. And just a word of particular note for today's discussion, all three of us on this panel have had very significant involvement in the pay data collection issues that we're going to be discussing today. Specifically, Nita Beecher was involved. She was actually a member of the National Academy of Sciences initial panel that provided the first report on the collection of pay data, and has some terrific insights on how the National Academy of Sciences process works, what's included in the reports. Bert Fishman has been very involved in filing very detailed comments on behalf of the Institute and a number of the Institute for Workplace Equality and a number of our clients addressing these issues. And I have had the privilege of, among other things, also providing information in a listening session that the second National Academy of Sciences panel held to understand employer concerns with respect to collection of paid data. So we all three feel like we have worked in these, toiled in the vineyards quite a bit, and we're really happy to spend the next 60 minutes trying to update you on what we have. So without further ado, Valerie, let's just jump right to the agenda, give you a quick overview of what we want to talk about. We want to spend a few minutes at the outset on the background and the context, because this report, the most recently issued National Academy of Sciences report, has an important historical context. And understanding what the agency, EEOC, and the other agencies are doing, it is important to understand how we got to where we are, and that also helps inform where we're going. So we want to spend a little bit of time unpacking the background. Then, of course, we want to spend the lion's share of time discussing what is in this most recent report. It is significant, 278 pages, I believe, and all three of us have been through the report multiple times. We'll discuss that in more detail. But it's very, very detailed and very, I'll call it geeky, very data intensive. But we want to share with you what the findings are by the National Academy of Sciences, some of the data issues that the National Academy of Sciences has identified that are very important, and then to unpack a little bit about the longer term recommendations that the NAS makes that are quite far reaching and not a rubber stamp on what has occurred to date, and then to pull out our crystal balls and share with you a little bit about what we think is going to happen, short-term and long-term, on some of those issues. So that's a lot of ground to cover, and I guess the best place to begin is perhaps at the beginning. And Nita, what say you? Why don't you kick that piece off for us?
Well, I'd be happy to. Well, let's talk about something that the NAS panel themselves talked about, which was that the EEO-1 report, the actual what we call Component 1 to distinguish it from pay, was developed and has been continuously used since 1966. And the panel in their webinar that they had on August the 2nd pointed out that that was created in a time when all of us remember there were no computers. Everything was done by hand, and all of that data had to be compiled and submitted in paper. So that's a context that I think is important as we move through this. One item that isn't on this list, David, as you will remember, is the OFCCP decided in the late Clinton era. All of these things seem to happen at the end of the administrations. And the late Clinton era, they instituted the EO survey, which is hated by all federal contractors. But to be honest, it's not dissimilar from what they ended up collecting with Component 2. That was only collected for a couple of years in the early 2000s and was officially done away with during the Bush administration. Fast forward. In 2010, there was a very important task force that President Obama put together, and I do think it's important. One of the things, there were two things I felt President Obama was very focused on. One was healthcare, and two was pay. And I think they're both related to his mother. But just moving that forward, they had a task force. I'm serious. I'm not kidding. I do think this was very important to him. There was a task force. It was called the National Task Force on Pay Equity. And out of that came and one of the things it supported paycheck fairness, which didn't pass. But it did direct the EEOC to collect pay data, which led to the first National Academy of Science report. And as David said, I was on that panel. They were put together in late 2010, early 2011. We met for about 18 months and then issued a report in 2012. And the question that was asked of that panel, which I think is important, was to prepare a comprehensive plan for the use of pay data, for the use of employer pay data. How do you collect it and how do you use it? And the bottom line, I think, which is important, and then I'm going to let David and Bert comment as well. There were two things I thought were really important that came out of that report when we sat down with the agencies and talked about it. One, that they needed to have a plan. And this was really, we had a meeting with the EEOC where the late Chair Berrien was, and after we gave her our report, she said, well, there was a whole discussion about what do they want to use the data for? And I think that continues to be a big issue. What do they want to use the data for? Because data geeks, way you collect data depends on what you're going to use it for. They said, and so the panel said, the first panel said, you need to have a comprehensive plan on what you're going to use it for. And then pilot it, neither of which they did. So that's the important thing. They also talked about that you shouldn't collect by pay bands, and I think most importantly, something we'll talk about a little bit later, that they needed to implement appropriate data protection techniques to protect the confidentiality of the data, and also needed to make sure that EEOC enhanced its capacity to summarize, analyze, and protect earnings and data. So that's kind of where the agency, Bert?
Yeah, Nita, perhaps you can pursue a little deeper. What was the nature of the EEOC's response when the panel asked, what is your intended use? Because as you pointed out, the end use will shape how you ask and what you ask. Did you ever get a good answer?
I think the answer that we really got was we want to see what the data says, and then we'll figure out what we'll use it for, which unfortunately is a very HRE response to data, and to which I think my chair was not very impressed, to be honest.
Right. Well, and I think, part of we need to remind everyone, the EEOC is principally a charge-driven agency, in contrast to OFCCP that does orchestrate and direct, generally speaking, which audits it conducts. EEOC is responsive to charges filed, and it typically does not target certain industries in the same manner that OFCCP or other agencies do with data. So that question was a critical one. Well, Nita, so they made these basic recommendations in 2012 and said do a pilot program and understand what you're going to collect so you collect the right information, do it efficiently, et cetera. Then what?
Well, they did have something they called a pilot program, but it wasn't the pilot program that had been recommended. But the next step, the next big step, honestly, was the President of the United States in 2016 comes out with EEOC Chair at the time, Jenny Yang, with him to announce that they would be doing what we call Component 2, that EEOC would be collecting pay data moving forward. And what we know, and David, I'd like a little bit of your thoughts on this, what it turned out to be was collection of W-2 Box 1 income and hours worked. And this was collected by the EEO job categories with 12 pay bands within each job category.
So, yeah, and Bert was very instrumental in drafting very detailed comments, pointing out many shortcomings that were there. I had the opportunity to present some thoughts to the EEOC. Suffice it to say, I think our concerns largely historically became a bit of a speed bump, and the EEOC proceeded as it had intended. I will say, and just on the historical landscape, at one point, OFCCP in 2015 actively looked at trying to collect pay information and deal with pay issues, focusing on the federal contractor community. I think the President's conclusion, the White House conclusion, was that that wasn't sufficient or wasn't being launched as effectively as they had hoped, and they really swung to EEOC to move forward and to get the job done. Yes, Bert.
You know, what eventually happened in 2016 seems to me to be a perfect example of a very ancient expression of haste making waste. You know, contrary to the NAS proposals, they use W-2 Box 1, and it's pretty clear to most of us that the reason they did so, for all of its problems and all of its limitations, was that they thought it was quickly available, that every employer had it. Everybody had to file taxes. Everybody had to file a W-2. And, you know, it was perhaps, as the second panel pointed out, and as we pointed out from the outset, it was one of the worst data sources that you could possibly have, because it doesn't include all compensation. It's variable year to year, so it doesn't provide a base. We suggested annual base pay, which most employers have for all kinds of purposes. But there was clearly, with the President standing next to the EEOC chairman, there is clearly a powerful incentive to do something and do it quickly, and they did, and frankly, it was a mess.
Well, and I think, of course, we're in an election year too, so let's move on, because what happened was exactly, they pushed it through, and in September of 2016, OMB approved it, and it was supposed to launch in March of 2018. And so we need to go forward 2 slides. And what happened at that point was, two more. One more.
We went backwards.
Anyway, 2017, what happened was, actually in 2016, what happened, the President of the United States was Donald Trump. And
one more
next
slide,
please.
One more slide.
Go ahead, Nita.
There we go.
That's it.
Okay. So in the middle of 2017, OMB stayed the Component 2 and sent it back to EEOC to review. But EEOC only had 2 Republicans. So it sat there, and subsequently in November of 2018, starting, I think, launched by the National Women's Law Center, a group of litigants sued over OMB's action, and subsequently in March of 2019, and David and Bert, I remember this as clearly on when this opinion came out, the federal district judge said OMB acted improperly, and EEOC had to collect the data by September in 2019, and that was crazy.
Exactly. So the federal district court orders that the pay data collection using W-2 Box 1, which, as Bert indicated, is all sorts. It's not just base pay. It's not just W-2 salary or wages, but it includes things like transfer supplements, various health care, various leave payments, all sorts of things that are for tax code purposes income, but are not what we think of when we do assessment of pay. Nonetheless, EEOC was dutifully ordered and at great expense to the agency, and I might add at great expense to the employer community. The data collection proceeded and went forward. Next.
And I think so. We go to the next slide. So meanwhile, they did collect the data. So what they did was they collected 2017 and 2018 pay data. So this was W-2, Box 1, by job category, EEO job category with the 12 pay bands within each from all private employers with 100 or more employees and also hours worked. It was one mess of a chart, to be honest. Just to close this out so we can get to the findings, in 2019, EEOC, now with 3 Republican commissioners, voted to not continue collecting Component 2 data, and but in 2020, they did ask the NAS to set up a new panel to do 2 things. One, and we'll talk about that, decide how they should collect, what data they should collect, and how they should collect pay data. And 2, look at the data they did collect and decide whether there was any quality to it. And that report was issued in July of the 28th, right as the National ILG conference was ending.
Right. So that really brings us up to where we are today. So there's this whole long history of the government in somewhat herky-jerky and under court order collecting pay data. Now the NAS comes back in and to give its assessment and to comment and evaluate basically what has occurred with that court-ordered pay data collection that every company on this call suffered through, and also to look forward, how should we collect pay data? How should that be done? So Bert, let's get into that. That's really now the meat of the report, where there's specific findings and recommendations that the NAS has provided.
Yeah, I'd be glad to do so. Just to also give a little bit of background to the second NAS panel, it was comprised largely of statisticians, self-described data geeks, very few policy people, no lawyers. This was really there to assess the quality and utility of the first data collection, and frankly, the report was quite harsh. The best light you could put on it was a bunch of people doing their best to say the nicest things they could while believing that this whole thing was a shambles. Their overwhelming and overarching conclusion is written here that the data collected was not well suited to measure pay equity by the EEOC or by employers, which goes back to the initial question we had for Nita. What was the purpose of this intended pay collection? How are you going to use the data? And it's really important, and we'll talk about this further, if it's not by use by employers, then there really is a question as to what the heck this data was for, because as David pointed out, the EEOC doesn't have an enforcement mechanism to use longitudinal pay data. The panel did point out, if you did it right, there is a utility to getting accurate and useful pay data, but the implication was this wasn't it. And they pointed out, of course, that there was that the data are incomplete, they have reliability issues, they need substantial cleaning. One of the conclusions, kind of unanimously of the panel, was that the EEOC, frankly, needed to redesign the entire data collection process. And the fact that you had to clean the data repeatedly is just an indication of the unhappiness, as it were, of the panel with the data that we had. And they really concluded that rather than redoing Component 2, which was the implication, I think, of the EEOC to just tell us how to do what we did a little better, the NAS panel was very strongly in a belief that you couldn't redo what you'd just done, and that you had to find well-established, improved data collection methods, which are currently in use at other federal agencies. And they pointed to the Bureau of Labor Statistics, they pointed to other agencies of the federal government, and the whole point was to do it better But if you want an overarching, subsuming conclusion of the NAS panel, is that the original pay data component 2 data collection did not yield useful data. And David, you had a point?
Yeah, a couple of thoughts on this. Number one, I do want to call out the EEOC issued a press release on July 28th, the day that this report came out, which Bert, you've alluded to this. The EEOC, I think, clearly expected that they were going to get effectively a green light. You can just press replay and just keep collecting pay data. It's very useful, and you should do that. Well, of course, the NAS report did not give a green light to simply pressing replay and repeat. They were highly critical of that, and they're highly critical not only of the data that had been collected, but said, don't keep doing this. So the press release by the EEOC, which in essence said, gosh, I think that we did a good job, or this underscores that what we're doing is well placed, was perhaps overly optimistic. Perhaps I hadn't read the report in its entirety. But bottom line, I think it was ultimately misleading, and that's unfortunate. I want to be very clear on that. Nita.
I think the reason, what's interesting is, I think as a result of the overly, shall we say, positive press release, you had two of the Republican commissioners, former chair Janet Dillon and Commissioner Keith Sonderling, issuing their own responses, basically calling out what needs to happen if, in fact, they're going to collect the pay data. The bottom line was that the panel felt that it was important that pay data be collected, but not in the way it was done.
Correct. Another point that I thought was very significant, and this ties back, and it's one of the reasons we wanted to unpack the history a little bit. As Nita indicated, the template that's being used is the 1966 template, largely, okay? That's before we had a man walk on the moon. I mean, that's not just last century. That's a very different time on many, many issues. The NAS, again, as Bert indicates, self-described data geeks, they make the point that the federal government routinely collects very robust workforce data. The Bureau of Labor Statistics, which is an agency within the U.S. Department of Labor, sole function is to collect workforce data, analyze it, and they have developed very robust categories for employees, how to put them in job grades and occupations and so forth, how to track EEO, what we think of as EEO data in great detail. And not surprisingly, the National Academy of Sciences said, well, why is the EEOC siloed over here using rather crude, limited data tools that don't yield much? Why don't you follow EEOC what the rest of the government is doing? And it isn't, and there are many other agencies beyond the Census Bureau, BLS, et cetera, that do this. So EEOC was, in that sense, called out. This 1966 model does not mesh well with how the federal government, in a very robust fashion, typically looks at workforce data. And the NAS, I think, was appropriately critical. Why would we keep using this collection tool?
You know, and one of the underlying problems, and we'll see this reflected, I think, going forward, is the EEOC's institutional commitment to what was pre-existing. The fact that they're using the EEO-1 form, which, you know, just think of all of the job categories multiplied by all of the pay bands, multiplied by all of the race and ethnic categories, yielded hundreds, and for some employers, thousands of boxes that were supposed to be filled, in no way related to the way companies actually compensate their employees. So the original panel pointed out that there would be endemic problems in going forward in this way, and they were correct. And the second panel, you might say, put pay to the very fact of the first panel's recommendations. If we could go to the next slide, we could also point to the recommendations, because in addition to simply coming to conclusions, the report had a series of recommendations of what needed to be done to make this more effective. And they did it in 2 stages. These are relatively short term, and we'll talk about longer term. The first was you've got to change the data you're collecting. And if you can't do a complete overhaul, at a minimum, you ought to switch from the W-2 Box 1 to W-2 Box 5. Box 5 is the Medicare earnings. It's still not fully complete. It still includes annual variables. So it's not, I don't think the panel would have thought that it's the best way, but it's certainly a short-term way. They also insisted in quite clear language that you had to narrow the pay bands, which were so big that you could not make distinctions among the very people that you're trying to learn whether there was equity. And the job categories were a distraction. And frankly, the ultimate goal of the NAS panel would be for the EEOC to eliminate pay bands and eliminate job categories and focus on individual pay data. That is the perfect solution for the data geeks. We'll talk about the policy and political problems with such data collection in a moment. They also pointed out that the EEOC, which you'd think would know better, failed to distinguish between exempt and non-exempt employees, failed to distinguish between part-time and full-time. And they said that if you're going to get paid data, you must make those minimal distinctions. And then if you're going to collect hours worked, you only ought to do it for the people for whom hours worked matter, that is to say, for non-exempts. And the most important is to repeat the ultimate conclusion of the first NAS panel. It sounds like a broken record, which is do a field test. Make sure what you're doing can be done, doesn't create difficulties and burdens for the people doing the data collection, doesn't create statistical difficulties in the analysis of the data. Do a meaningful field test before you maximize it for the entire economy. And they ought to do it before you start designing or start implementing a data collection. Nita?
Yeah, I think what's really important here is the reason they were collecting pay hours worked was because they insisted that they were going to do this analysis. They were going to figure out what everybody was working, number of hours, and then calculate up against the pay data they were collecting. And I think unless you're going to collect individualized data, you're still going to have an issue with hours worked because you're not going to be able to determine what the rates of pay are. But we'll talk about that in a minute. The hours worked data was terrible and really can't be used for anything. You cannot figure out rates of pay with the data they collected in this case.
Nita,
well,
just
they were hoping
for more historical background, do you know why the EEOC elected not to do a meaningful field test?
I think they ran out of time, to be perfectly honest.
Right. They were under political pressure. Recall, it was, remember, it was initially going to go forward under President Obama's watch. Then it ultimately went forward under direction of the federal court. And there was, the judge was not in the mood to hear, don't talk to me about field tests. I mean, she gave EEOC minimum running room to try to get a consultant and to be able to actually upload the data. So there were a lot of stresses there. I think that one of the other flaws that was baked in, that in the initial data collection that was called out effectively, the EEOC was also quite suspect of whether employees were classified as exempt. And they felt that there was gross misclassification. And so rather than simply collecting pay data as it is, they were also trying to probe and effectively convert every employee to an hourly rate. That way they could compare hourly rates, whether you're exempt, non-exempt, and so forth. So this elaborate data collection was premised on the fact that a relatively modest number of employers possibly misclassified certain exempt employees. And we built this enormous data infrastructure to chase that, which of course crashed in on itself. Nita.
Let's go back to point number 1. What are you trying to do with the data you collect? And that is an ongoing issue. But let's talk about the data just for a minute, going to the next slide. I mean, these were their initial recommendations, but the other part of this was, what did the data you collect, as we talked about a little bit, what did it really show? Well, there were all kinds of issues. Some of them were really data geeky issues, like the data coverage was only for 58% of the eligible firms and only 55% of the eligible establishments. Now, that is in contrast to the data collected represented 90% of the people who had filed the year before. So there's a disconnect. The EEOC is not updating their list. They are not doing what they need to do to update the list so they have the latest employers on the list and are filing. And we know that is a real issue. Reliability issues with the second thing. So they have coverage, then reliability. Lots of extreme errors, internal consistency. So they had to exclude, of all this data that was collected, 35% of it was unusable. So they had to completely eliminate it. So they're not even using all the data that was collected. And David and Bert, this ongoing issue of what measures of sex, race, and ethnicity do we use? We know that the American Community Survey collects unbelievable numbers of minute data about people's race and ethnicity. And EEOC back in 2003 made a decision that they were not going to allow those who identified as Hispanic or Latino to also identify by race. And that's one of the issues that the panel raised as well. And finally, there was a lot of inconsistency with the firm and establishment data. Again, some of this was definitely related to having to turn around and do this in just a couple of months. Other thoughts, Bert and David?
I think the most telling is the fact that the idea of the entire process did not include some mechanism to clean the data reliability. If you're going to do a data collection, the first screen you have to have is to assure yourself that the data you're getting is the data you need. And perhaps it's haste, but this goes to plan design. And you can talk about how hastily the plan was implemented. These are problems with plan design, and they had 2 years to design this. And this is what they came up with. It's a blot on the EEOC's escutcheon.
Well, and it was they had a roadmap of a pretty sound design provided by the first NAS panel that was largely not followed. These shortcomings were anticipated. Some of the shortcomings, frankly, were anticipated in the input that we provided and others, and certainly the NAS recommendations. And so we shouldn't be terribly surprised that there are these shortcomings. I would also add, historically, when these data first rolled in the OFCCP's initial reaction, now again, this was not under the Biden administration, the initial reaction was, gosh, these data, we can't really do anything. And people didn't really understand, because we were like, really? A lot of people thought, well, maybe this is really going to power OFCCP, enable them to really get focused, because they're focused on comp. Can't they use the data? Well, now, with the benefit of kind of looking intensely at the data as through with the benefit of the NAS assessment, now we see the old expression, GIGO, garbage in, garbage out. And OFCCP initially, now they've since, I think, tried to amend or back off this conclusion, but the OFCCP's conclusion under then Director Craig Lean was, we can't use these data. They are a very limited utility for OFCCP in selecting and auditing federal contractors. And now we know why. This report bears out that those conclusions were exactly right. Nita.
So as we go to the next slide, let me just say that the panel, when I first got on the panel, it was pretty clear that, at least initially, they thought the original panel was thinking that, oh, we'll just add this to the EEO-1, that was initially the idea. But as they got more and more into it, and I thought one of the most interesting comments made by our chair at one point was that the type of data that's collected by the EEO-1, which is race and gender and ethnicity data, is different from pay, and that it has to be collected differently. And we're going to see that here in just a minute as we talk about what their next recommendations are. But just let me walk a little bit through these next things that they found in the data, which basically were what we expected. It has limited utility. It can only, this is all this data they collected, for which the EEOC spent hundreds of millions of dollars collecting this data because they had to run out and hire somebody to help them. And it can only estimate raw pay gaps at the national level by sex, race, ethnicity, and occupation. Maybe it can help EEOC prioritize initial investigations, and they did focus on some tech industry data, which must have been extremely, they could see by looking at it that there were some issues there. It is not suitable for direct determinations of bias or for determining reasonable cause. The hours worked are garbage. They basically cannot be used to calculate our hourly wages without extensive cleaning. And one of the reasons the EEOC wanted to collect this data was to help employers do self-assessments. It has limited utilities for self-assessments. Bert?
Yeah, if I could just comment on that last bullet. You know, David talked earlier about the mission of the EEOC and how they work, that it's a charge-based organization, and that they don't have either the authority or the will to do a massive investigation based on longitudinal data. So one purpose of a pay equity study would be to help individual employers analyze their own pay data and learn from the data how they themselves could address issues of pay equity in their own companies. But this data was so poorly imagined and poorly designed. This data collection was so poorly imagined and so poorly designed that the people collecting the data and submitting it to the EEOC couldn't even use it for self-assessment. And since this is, we're a government where the will of the people is what rules the government, here employers wanting to do the right thing, going to the process of collecting compensation data for the purpose of understanding pay equity issues, couldn't even use the data for that purpose. And from a data geek's point of view, from the panel's point of view, this is code for this was a waste of time. And it's a very damning comment.
Let me just add one thing, because EEOC, as they were, a couple years ago, as they were starting to look at, are we going to collect this pay data, beginning with Chair Lipnick and then continuing with Chair Dillon, there was recognition that the agency was not ready to take on this type of massive data collection and analytics. And they began by creating a very robust shop of subject matter experts headed by Dr. Chris Hafer, who is very strong in this area. And they were in the process of building that process up so that they would be able to direct, collect, and make sure and to deal with all these, potential shortcomings that we've identified. What no one anticipated was that the federal district court would be joining the party and directing, I don't care what the cost is, I don't want to hear that you as an agency aren't ready, just go forward and do it. And Bert, as you said before, haste makes waste, but it made a total hash of it. And so EEOC was not unmindful that these problems could occur, but those objections were summarily overruled and pushed aside by the district court. And that is really unfortunate, really unfortunate. This was done largely for other reasons, and the outcome has resulted in massive waste, I think, by government agencies and the business community in having to respond to this. All right. Well, we've covered those limitations, so we don't, not much good there. What else does the report have for us?
Well, David, I think we want to talk about the longer-term recommendations there, which are, yep.
So This is something where it's like, okay, it didn't go so well the first time. The NAS, to be fair, has said, but there could be a benefit to the government collecting pay data. I mean, that's not completely out of line. And EEOC, by the way, and we'll talk about this a little more, does share the data it collects, as we know, with the Labor Department and with states. So there's a lot of consumers of this data. And so the NAS says that's kind of good, collecting data and enabling people to be on the same page. But if you're going to do it, and this is where the disconnect is with the EEOC's initial press release, you cannot do it the same way you just did. You have to change. And this is where, and this is not a pro-employer point at all, but the NAS said, being data people, let's get as much data as possible. Let's collect individual employee data, not by bands, not by groups. Let's just have every single employee on a roster and collect what the data are. And let's not just collect pay data, let's collect a whole bunch of data so that we, in theory, can figure out why people are paid what they're paid and if they're paid fairly, such as education, job experience, tenure. And all of this will help us identify if there's pay disparities, what the source of it is. Now, I can hear the gasp by many employers going, wait a minute, we don't even have that. I mean, how would we do that? I mean, put aside, there are many practical concerns. And I want to underscore a point that was made earlier. These were only data and demographer specialists. These are people who love data. The more data, the better. They don't get hung up on how you get the data, what the burdens are. Can the agency actually collect all that data? Should it? The policy issues? No. But this was their recommendation. Obviously, I put a marker down. Many employers have great concerns on that. But that's only one area that they said. I mean, this is sort of like the whole enchilada. It's like, while we're at it, why are we going to keep using this 1966 template? Let's get rid of that. The EEO-1 standards, as we've talked about, those don't work so well. Let's look at those standard occupational classifications. Why don't we collect data based on that? And also, while we're at it, let's not use the existing Title VII 11246 classifications. Let's get into extreme granularity that allow people to pick not just multi-race, but which racial subcategories, not just Native American, but which tribe, et cetera, not just Asian, but which national or ethnicity within that. So these are far-reaching, and candidly, even for employers that have very robust diversity data collection efforts, may and typically will outstrip the data that most of our clients would have sitting on their servers. And finally, and this was a little bit of I thought, a slight embarrassment, and should have not have occurred. The NAS did not actually understand which statutes the EEOC has jurisdiction over. And they said, and while we're at it, EEOC, why don't you collect data on veterans, for example, and so forth, which of course, that's a Labor Department program, and the EEOC can't do it. And people over 40, which is an age program, it's not under Title VII. But, if you're a demographer, let's get all the workforce data we can. Mm-hmm. I get that. But again, the panel didn't have the benefit of having Nita or someone of Nita's expertise on the panel this time, and they made a self-inflicted error. But it diminishes from what you would expect of a panel of this caliber. And finally, we're not going to have Component 1 and Component 2 on this dream scenario by NAS. We'll just have one brand new data collection form, and we'll do it all as one. So let me stop there. I mean, this kind of takes your breath away when you think about the extensiveness of this. Nita.
How many employers use standard occupational classifications and have that readily available? And I think the answer to that is zero. I mean, there are other things they could use. That is used, obviously, for the Bureau of Labor Statistics, but I don't know that employers, as part of their HRIS system, have any of this data. I don't disagree. I mean, if we were doing, so David, if we were doing a pay data study for a client, what data would we be asking for? All the things on this list, right?
Potentially, we'd typically start with base pay. We'd start with basic information. Then, if we had potential flags and the information was available, we might add in, for those additional employees, that additional information. But this dialogue that Nita and I just had underscores one significant point. The federal government and the NAS is thinking about collecting omnibus data for everyone, whether it's necessary or not. And that bothers me. Bert.
Yeah, and we'll talk about this later, and the limitations of the panel, because these are, as their own word, data geeks. I mean, one of the overwhelming issues with respect to the kinds of data they're saying is a privacy issue, which has become more and more significant as the invasions and surveillance notions of the internet become more manifest. The very idea that you would be asking for this granular level of personal information to be disclosed to the government raises enormous policy issues, enormous philosophical issues, enormous issues for our democracy.
Let me just raise a very specific example in real time. Under existing MOUs, the compensation data that the EEOC collects is shared with other agencies. It's shared with the Labor Department, and it is shared with the states, okay? So currently, this week, the Labor Department has received a FOIA request for all employers who responded to the first EEO component, EEO-1 Component 2 comp data collection, for all of those pay data to be disclosed to a newspaper reporter. All employers in the United States. That is the pending FOIA request. It has just been received this week, and the only thing that stands between disclosing the United States employers' responses to this reporter publicly is the Freedom of Information Act and whether proper objections can or cannot be raised. The history on that is a little weak, and this is one of the stated concerns. There also, keep in mind, each state gets this, and each state has its own particular vagaries on whether they do or don't take good care of information. EEOC, in contrast, actually has criminal statutes that protect the integrity of the data, and our experience has been EEOC is a very good custodian and has very robust protocols. And again, I want to call out Dr. Chris Hafer, who implemented even more robust protocols to make sure that when the EEOC had the data, they treated it accordingly. Nita, did you?
I think we ought to go to the next slide, David, because I think this starts really this discussion. And you know what's troubling is, at least initially, the EEOC has, or the OFCCP has received this FOIA request for Type A EEO-1 Component 1 data for all federal contractors, but clearly OFCCP has said that they want to receive the Component 2 data, and so clearly any of this data that would be protected at EEOC would not be protected except by FOIA once it goes over, especially individual pay data, over to OFCCP, which could be FOIA'd. And one point I wanted to make was that was a question that was raised and made by our panel. In particular, they said they should change Title VII to require that everyone who got the data had to protect it the way the EEOC did.
Another important recommendation that was disregarded. Bert, we've talked about some of the press comments, public comments. What about some of the other aspects that you see on the EEOC, please?
Well, I think we have to talk about some political realities. In order for this to go forward, the EEOC has to vote to do so. Currently, the EEOC has a 3-2 Republican majority. Former Chairman Dillon's term has expired, but because a nominee, Ms. Kodegal, has been named, Ms. Dillon can stay on at least through the year. Whether and to what degree Ms. Kodegal is going to be confirmed is a significant question. Congress is out. The number of legislative days are few. The midterm election is coming. And from my personal point of view, I don't think I'm not betting that Ms. Kodegal is going to get an easy or quick nomination, which enormously complicates the ability of the EEOC to go forward to implement this new data collection. David?
Right. And so the nominee, she did not make it out of the committee. It was an 11-11 tie, which means that there have to be at least 2 separate independent votes by the U.S. Senate for her confirmation. Exactly. That is a bit of a challenge, number one. Number two, in terms of what the commission must do, this is a data gathering, so it's not necessarily a regulation, but under the rules that govern, the agency can't just serendipity say we want to do whatever. There are requirements under the Paperwork Reduction Act and a number of other statutes that regulate and that require an agency to prove that it's cost effective, the cost benefit analysis of the burden put on collecting data versus the benefit of how the data will be used. And against those general criteria, we now have the NAS criticisms of what occurred before. So the EEOC is going to have to be able to overcome and address the shortcomings and the burdens that have been identified now, the lack of utility, to put it in their parlance, of the data that was collected, and to be able to justify that. So that requires first the 3 votes to get it out of the commission, then it requires approval by OMB, White House, and that will not be perfunctory. They do have requirements and obligations independent to assess that. Nita.
And David, let's just take it one more step. We talk about EPA versus West Virginia. Many of the statutes that they were citing, let's put Title VII aside just for a minute, ADA and ADEA do not have specific data collection provisions in the statute. Title VII does. It is very vague. It talks about demographic, and it doesn't talk about pay. So I think with a more focused, shall we say, judiciary on what, in fact, agencies can do, it's possible that robust pay data collection might be found to be not allowed under Title VII even.
Yeah, I think that's right. Based on the textualist court, the very focus on that. Bert, go ahead.
Yeah, I think if you look at the so-called non-delegation language in the OSHA case and in the West Virginia case, I think the EEOC will be hard-pressed to point to the specific congressional authorization to collect pay data in this or any form, and they ought to be very careful because the judges will look at that with strict scrutiny.
Let me just say one thing about the congressional aspects. I mean, it's no secret we have a midterm election coming up. Many are prognosticating that potentially the House will change leadership, that the Republicans may be driving that. And even so, let's just play with that scenario for a moment. That's not only where budgets originate, but that the current minority chair, she would become the majority chair, Dr. Virginia Fox of the relevant committee of jurisdiction, has been highly critical of the EEOC collecting pay data, highly critical, and indicated that she is extremely concerned about the burdens employers face, about the utility, about what the government is doing with the data, many of the concerns. So it is quite likely that if the EEOC would try to get out of the blocks quickly and there was a Republican House, the prospects of oversight or further questioning as Congress can do, and Congress, trust me, can make an agency's life really challenging if they embark on that. Bert.
And don't forget the Congressional Review Act. If this is in the form of a regulation, by a simple majority, each House of Congress can block a regulation.
Right. And it's not only, Bert, under Congressional Review Act, just to remind our listeners, it's not just that they block that regulation. Congressional Review Act, I always refer to it as the neutron bomb. It says, and in the future, the agency is prohibited from any similar regulation in that field, which effectively would mean EEOC would then be barred from collecting pay data, not just rolling back the reg, barred from collecting pay data. Think about the OSHA ergonomic rule. That's exactly what happened to it. So those things do happen, and they're quite significant when they do.
So, David, do we want to have some final thoughts as we get ready to roll out here?
yeah, do that. And so, okay, there are all these limitations. So what is going to happen? This is what people want to know. And I just want to note, we did get a comment, that there are multiple influencing factors with EEOC's ability to proceed. I think we've touched on most of these: a midterm election, current EEOC commissioner makeup, the federal budget, and that goes back to the composition of the House and so forth, rulemaking. Should employers take a wait-and-see approach, or is there immediate must-dos for businesses at this time? Well, let's sort of weave that in about what employers, because I think there are some must-dos or thoughts that we can do. But let's start with, what's the EEOC going to do? And Bert, do you want to take that?
I'll take a run. If they can get their act together and want to go forward with trying to do data collection, I think they're going to accept the recommendation to do W-2 Box 5, and then they're going to try to rerun it as close to what they have as possible. But they have time constraints. We've already talked about the limitation on legislative days before the election. They don't have a voting majority. There are political considerations. I think the institutional inertia of the EEOC also has to be borne in mind. If I had to give you a yes or no, I don't think this is going to happen. But that's what I think they're going to try to do.
Let me just say a word on OFC. I'll key that one off, because one of the other customers, users of this data, was intended to be the Labor Department and the OFCCP. One of the priorities is focusing on compensation. OFCCP has a record of trying to litigate very high-profile cases. Its record is pretty abysmal on that front, and it's also trying to get focused in terms of audit activity and to really use its limited resources where there has reason to believe there are problems. One of the tools that OFCCP has been using now for several years is a creature known as a pay analysis group. It's unique to OFCCP audits. It is not recognized by the courts, but it's a device that OFC has developed and used to assess and to compare employees that are in very broad groupings. One of the tools that OFC uses in developing its pay analysis groups, they often use EEO-1 job categories as an organizing tool in assessing federal contractors' pay. I think one immediate takeaway is anyone that's facing an OFCCP audit, if they start rolling out the EEO-1 job category analytics, which they almost always do in every single audit, you should immediately dust off that copy of the report, the relevant provisions that say, look, this has very limited utility. You cannot use this for assessing specific employers' compliance, etc. There are lots of nuggets that are worthy of quoting to OFCCP and asking that they deploy a more meaningful, responsible, and accurate analysis.
Well, David, and I think the other thing, talking about whether employers need to jump up and down and get really upset about this, I think there's a whole lot of questions left that need to be answered. And I think, assuming that EEOC is at some point going to reach out to the shareholders, their stakeholders, and talk about this, they haven't addressed confidentiality. They haven't addressed the burden. They haven't addressed the privacy issues. They're not really addressed in this report. And I think EEOC is going to have to address those before they even think about sending something up to OMB for approval.
Absolutely.
One of the things, and we have another comment, EEOC taking steps to educate employers as to how they may assess their own pay equity, the test for multi-regression analysis. Is EEOC doing that? EEOC has started some limited listening sessions. They also are in the process of developing their own strategic enforcement plan for the next 5 years, where they're starting to grapple with this, but they have not yet, since July 28th, announced, to my knowledge, any specific uptick or response beyond the initial press release that we noted. One other thing, just briefly, while the federal government for the last 15 plus years has been ping-ponging back and forth, the states are moving forward. They're much more streamlined. California, they're out collecting Box 5. Illinois is now collecting individual employee comp data, and that's in place. Other states are on the cusp of moving into that. So very quickly, the landscape is going to continue to evolve, even if the federal government is stalled or in irons a little bit, to use a sailing term. The states will continue because they have the luxury of being more streamlined. Bert?
Yeah, and this goes back to the first question of what to do now. Please learn your state law. I know most of us think of these things in federal terms, but clearly the court is moving in the direction of the Articles of Confederation. Start thinking about where you do business, because you're going to be perhaps made to disclose information on a state-by-state basis in a very different and far more granular way than the federal government is thinking of.
Okay, we're just right on our time. Valerie, just next slide. I want to thank both Bert and Nita, and I would encourage anyone who's interested, contact us at info@FortneyScott.com, info@FortneyScott.com for a copy of this deck. When you get the deck, each of these sources of additional information is linked in the deck and available to you. So we have not only a copy of the report, if you really want to delve into this, both the 2022 report and the first report. You can have both reports. We've done a client alert. We have a great podcast, if I do say so. It's gotten lots of clicks, and we do that DC Insider, What Employers Need to Know, Employer Update podcast. Please listen to that. Click on join, subscribe to it. We would love that. And also we copied the NAS webinar, which I think is very helpful. They did their own rollout of their report, and there's a copy of that we have available for you. So those are all great tools. Those that want more, be in touch. We appreciate all of you joining us, and both Bert and Nita, thank you very much for sharing your expertise and time with us today. Thank you.
Thanks for joining, folks.
We would like to thank you for joining us today on our webinar. At the end of this presentation, you will receive a survey requesting feedback for today's webinar. You will also be able to submit suggestions for future topics through this survey. Thank you in advance for completing the survey, and of course, if you have any questions, you may submit them via email to info@FortneyScott.com.
Okay, Valerie, thank you. And for those, if the audio was weak, you're going to get a survey. We would appreciate your input, and hit us at info@FortneyScott.com and check out the podcast. All right. Thanks, everyone. Have a good day.